Well, good afternoon, everyone. It's always one of those weird things at the start of these that you never quite know if it's going or not, but I'm sure someone will shout if it's not. This is Archer's presentation on bonds, guarantees and other security. It's given another title, which I'll come on to in a moment. I'm joined today by my colleague Simon Franklin, who's a legal director, and Shahbaz Mohammed, who's an associate. They're both in our Cambridge office, which is all very exciting as we opened it just over a week ago. And Simon has been with us a full 9 days. Shahbaz has been with us 6 months. And hopefully they'll push forward our new Cambridge offering as well as part of the overall Archer business. So the other title is Security is Not a Dirty Word. Now, for those of you of a certain age, you may remember this from Blackadder. And just to properly remind you, I believe Lord Melchett says, security is not a dirty word, Blackadder. Crevice is a dirty word. Now, for some of you of a certain age, that will mean something. For a lot of you, you'll think the guy's mad. I suppose, other than it's come from Blackadder, the point is security is one of those things that is needed on any, or it needs to be considered on any job, be it a building job, civil's job. And I know this is a CICES talk, so obviously it's a civils issue. It needs to be considered at main contract level, subcontract level. And, you know, it doesn't take a rocket scientist to work out recent events of ISG, Henry Construction, Buckingham Group, you know, all those issues will have caused major problems. And if you haven't got security, then you're going to be left out of pocket. So we're going to talk about various types of security, and we're going to split that into 3 parts so you don't have to listen to me with my cold all the way through. I'm just dealing with bonds. Shahbaz is dealing with guarantees, and then Simon is picking up the rest: project bank accounts, escrow agreements, etc. Almost every time I use a picture, there's a reason for it. That's a double-sided mirror because guarantees tend to go both ways. You know, sometimes they're funny and sometimes they're not. So moving on to bonds. So, and I should just say on this slide that my head isn't quite that fat. It's just in order to fit over the image of James Bond, I needed to stretch it a bit. So the issues are, you know, why are people using a bond? What types exist? Comparing the on-demand type versus conditional. How adjudication works with bonds, and then a brief discussion about what we're seeing in the current market, because the bond market has changed as a result of various large insolvencies. I mean, you never quite know, but Henry Construction, it was rumored at least they had £150 million worth of bonds. ISG, the suggestion is they had 60-70 million pounds worth of bonds. Now, those bonds are going to be called upon. The bond provider is going to have to pay out, which essentially are insurance companies. They're therefore less inclined to give new bonds, or they're going to charge more. So all of these things put together mean that the bond market is in a state of flux. So we'll give you an example of what we're seeing in the market. So the primary reason to get a bond is you've got overall concerns about the solvency of a particular party in the chain. And what you're after there is some kind of security. Now, you want security if that person goes into insolvency. You may also want security for other examples, such as where there's an advance payment being made, where you're paying for offsite materials, where you may have agreed not to deduct retention. Often that's then followed up with a retention bond. So these are all, you're after security essentially for the money you've paid or the money, you know, you're going to pay to finish the job. Another reason worth remembering is that quite often you have to have a bond because the funder requires you to have one. And, you know, let's be realistic, projects don't get built unless there's a funder providing the money. And as I've just said already, there are, you know, the current market conditions. Reading this morning that the construction, you know, is on the up, but of course you still got the lag of what's happened before, and say ISG are perhaps the best example of that in recent times. So what are the types of bond you get? Well, essentially they fall down to on-demand or conditional. Now, I've already talked about retention, advance payment, and off-site material bonds. That there are specific types of bonds, and the other type, which is the primary type, is performance bonds. So that is where you are being given security for typically 10% of the value of the contract from a bond provider, which is typically an insurance company. Those bonds, which I'll come on to, are conditional, albeit, I'll come on to what that means, albeit on-demand bonds to cover performance bonds are now part of the market, and I'll come on to why that's perhaps a bit of a false requirement, because in order to have an on-demand bond, the money's got to be stuck somewhere else, so you almost might as well not bother. So on-demand versus conditional. So an on-demand bond is, as the words say, it's an undertaking from the person providing the bond, so the bond provider, to pay a given sum without reference to the liability of the contractor. So effectively, they're asked to pay some money, they pay it. No suggestion of breach, no suggestion of querying whether it's the right value or not. The only basis upon which you don't have to pay a sum under an on-demand bond is if there is clear fraud. Not unheard of, must be said, but is if there's clear fraud. Now, a secondary obligation in the background, that's the coffee man just arriving. The secondary obligation is where the bond provider has a liability to pay contingent upon a breach being demonstrated. And that breach has to be established under the contract, as well as the value claimed being established under the contract. So that's the difference between the two. Where you see the difference is as well. So the typical UK-based performance bond is conditional. It requires a breach of the bond before any payment is made. For retention, advance payment, and off-site materials, the argument here is that the employer, the contractor, if it's the subcontractor, is paying effectively in advance, and therefore they want security if the person goes into insolvency before the materials arrive, before the payment is paid off, before the end of the rectification period. So those documents tend to be on demand. So as much as the money is paid, it can be called back at any time. And there are standard forms in JCT contracts, for example, and other forms of contract that actually have that. The old days, you used to get international performance bonds that were on demand. And the classic example was a job in Libya. The job would be one day from practical completion. All of a sudden, there'd be a call on this on-demand bond, no justification, and it has to be paid. And what used to happen is companies working in Libya used to add the value of the bond onto their contract sum because they knew they were going to have it taken off at the end. What we are seeing is that in the UK construction industry, there's now a demand for on-demand bonds. Now, the problem with an on-demand bond is the person willing to sign an on-demand bond is typically a bank. A bank will own, and the bank's not interested in whether there's been a breach or not. So the bank will only agree to sign that bond if they have that amount of security elsewhere. So almost you have to have the money sitting in a bank account in order to give the bond. Well, you might as well put that money in an escrow account, which Simon will come on to later, and don't pay for the bond. So having on-demand bonds, for most companies means that they've got to have the money sitting somewhere anyway. So that is a bit of a false use of time, really, and money. So what you see in most cases in the UK construction industry is performance-based conditional performance bonds. So as I said, you can work out that Planter 39 is a conditional or something. So the first thing to say about conditional bonds is they need to be approved by your bond provider. And it doesn't really matter what I think or any other lawyer thinks. If it's not in a form that can be approved by the bond provider, then it's not going to be signed. And lawyers, developers, funders need to recognize that if the market is shifting, so various clauses are acceptable, various clauses are not, that's what needs to be in it. I'm going to talk about some legal provisions in bonds because it is actually a talk about law. But yeah, the primary things you're looking at are, what amounts to a breach, and in particular, does insolvency amount to a breach? Because there is a sort of semi-misunderstanding about that. Is there any form of intermediate recovery under the bond? And I'll come on to why that's necessary. The things we're seeing in the market is the size of the bond changing. We have seen some 20% bonds. Now, again, if you're going to have a 20% bond, you're going to pay a lot of money for it because the bond provider is liable for more. And also, what's the expiry date? And we're seeing the expiry date change because contractors can only have certain size pots of bonds. And if a bond is sitting there for an extra 12 months when really it's not needed, it restricts that contractor from obtaining other bonds for other schemes. So what is a breach under a bond? Well, in almost every bond, you will see wording like this. It doesn't help. The people who draft bonds often refer to the bond provider as the guarantor or the surety, or they're strictly a surety, even though they use the word guarantor. But this is bond wording, and it says the guarantor guarantees in the event of a breach, they will satisfy the damages sustained by the employer as established and ascertained. And those two things are important to understand. There has to be a breach, and the employer has to establish the loss. So first sort of legal issue is PARA versus general surety. And this all relates to whether insolvency amounts to a breach. Now, in some contracts, JCT, for example, insolvency is not a breach. Clearly, if someone's insolvent, they're very unlikely to be carrying on with the work, although it is theoretically possible. But if someone's insolvent, under some contracts, that's not a breach. The breach is the failure to carry on with the work or the failure to pay money due. And PARA is an example where went to the Court of Appeal, but it was a very odd bond in that PARA had to notify the particular breach within a particular period of time under the bond. So they notified general surety that due to the insolvency of the contractor, that was a breach. They're therefore making a call under the bond. That was incorrect. They then lost their time to make a different call. The Court of Appeal said insolvency is not a breach. Therefore, you can't rely on that breach as part of the bond. This has led people to think insolvency isn't covered by a bond, and it is, but what you typically see is the bond drafted in such a way that insolvency is expressly referred to as a breach sufficient to enable you to call on the bond. And the problem that arises, and I've referred to a case here called Ziggurat and HCC. So His Honour Justice Coulson at the time went through this and essentially said, look, termination is good enough, insolvency is good enough because it leads to termination, which leads to money owing. And the argument or the way it works is that when a contractor goes into insolvency, there's no further sums due and payable until the job's finished. The insolvency itself isn't a breach. The breach occurs when the contractor doesn't pay the debt that is due and owing, and that debt is due and owing at the end of the job, at the end of the rectification period. So the employer employs a new contractor to finish the works, does a reconciliation at the end, almost invariably has paid more. He then writes to the contractor who is insolvent and says, please pay this money. They don't pay the money, therefore that's the breach. So the breach is not paying the debt. The insolvency itself isn't a breach. That said, it's probably safer if you have a bond to make sure that insolvency is specified as a breach. But what you'll gather from what I've just said is you can't strictly ascertain the sum due until the end of the rectification period. Now that in itself is a problem, because the person who wants the money from the bond, typically the employer, really wants that money to finish the job. The employer's got to finish the job first, get to the end of the defects period, and then claim the money back. So what we have seen, and we increasingly see, is what you will see as interim assessment provisions, which effectively allow, on the insolvency of a contractor, as the words here, the employer can make an intermediate claim under the bond. Our experience is almost every bond claim we have, the claim is so in excess of the bond value that it becomes a bit of a non-point, that you almost don't need to prove it because there's so much loss that flows that the bond is just a drop in the ocean. But this allows the employer to put forward their view of life, allows the surety to say what their view is, and if they can't agree, then it's decided by, in this case, it's an expert surveyor. The rest of the clause goes on, and that intermediate decision has to be paid straight away. If then subsequently the number is higher or lower, and subject to the bond having any sort of room left in it, that's what's paid. So you see quite a lot of that in the market now. And the other thing is, well, how does adjudication work with a bond? So you've got what we're seeing in bonds is express words that say, following an adjudication decision, a court that amounts to estimated and ascertained. And even though an adjudication decision, it was thought because an adjudication decision was an interim decision, that wouldn't be sufficient to enable you to call on the bond. We see express words that say, if there's an adjudication decision, you can call on the bond, but also the case of Uanda and Multiplex makes it clear that an adjudication decision is sufficient to amount to establish and ascertain. So even if you don't have the words, you can rely on the case law to get you over the line. Where on-demand bonds are concerned, they are, as they say, you get a demand, you have to pay it. You'll see a lot of people who are not experienced in understanding bonds confusing some conditional bonds as on demand. So for example, if a bond says, you know, if a sum becomes due, you will pay on first written demand a certain sum of money, that is not in itself an on-demand bond because the sum has to become due first. So the condition is, can you demonstrate the sum is due? So most UK bonds are conditional. So the ones that are different tend to be offsite materials, advance payments. This is taken from a JCT. This basically says if you get a piece of paper from someone who's authenticated to sign it, you have to pay it back. And that is the way on-demand bonds work. My final slide is how we're seeing the bond market. Well, as I've already discussed, Henry and ISG in particular have altered the appetite for the bond market. I believe QBE may no longer be interested in bonds. So what we're seeing is higher prices. And if you're coming new to the market, trying to get a bond is very difficult. We're seeing more demand for on-demand bonds or changing the terms. So if you've got a bond, you can call on it earlier than having to wait to the end of the rectification period. And then we're also seeing, you know, who is giving bonds. So is it of a sufficient, you know, is the bond, because we're having bond providers go into insolvency as well? And where's it coming from? Because often you'll get a bond from somewhere in Gibraltar or Turkey or something. And if you ever have to bring that claim, how easy is it to bring that claim? One final point is on the expiry date. As I said earlier, we're seeing a lot of bonds expire 3 months after PC. And that is because if you're a contractor that needs to provide bonds, you know, you need the room in your bond pot. And if you've got old bonds that are never going to be called on but are sitting there for another 12 months, you lose the ability to raise any other bonds. So because the bond market is getting more difficult, we're seeing the increasing use of guarantees. So I'm going to push you on to guarantees. I'm going to seamlessly get rid of my microphone, and hopefully I'm going to have to get my glasses on so I can't actually see the microphone. And my
So we move on to guarantees now. So the law of guarantees goes back quite a long way, almost 400 years. Just if Andrew, if you can move on to the next slide. Yeah, I'm not quite sure how accurate Andrew's attempt at linking Blackadder 2 to 1677 is. I think he's off about 80 years, but yeah, the point stands. The law surrounding guarantees goes back quite a long way, all the way to the Statute of Frauds, which was in 1677. So yeah, to be enforceable, a guarantee instrument must be evidenced in writing and signed by the issuer, and that's section 4 of the statute. And this piece of legislation still remains valid and is referred to in one of the cases I'll touch on later. A guarantee must be in writing, so an email is fine, but it will need to be secure. And any oral guarantee, however, is simply not good enough. So typically the type of guarantee we use in the construction industry are known as see-to-it guarantees. They're also known as a pure guarantee. And you've got an example of one there on your slide. So a guarantee under which the guarantor promises to see to it that the principal obliger will fulfill its obligations under the primary agreement between the principal obliger and the beneficiary. If the principal obliger fails to fulfill the guaranteed obligation, it will be in breach under the primary agreement, and the guarantor will automatically be in breach of its obligations under the guarantee. So essentially, what that clause aims to say is that the guarantor is agreeing to see to the obligations of the primary obliger, and the primary obliger is the contractor. So we move on to the types of guarantees and who we are getting them from. So number of type of guarantees that we can use in construction projects. The classic form of guarantee are parent company guarantees, typically provided by the parent company of the contractor. In circumstances where there's some concern over the solvency of the employer, one option is a payment guarantee from the employer's parent. And we also see the use of personal guarantees now and before. So this type of guarantee is far more common for the smaller scale works where the companies are small and a director guaranteeing a small company provides security for the employer. We'll come on to this later as well in terms of signing of builders merchant terms. So why use a guarantee and not a bond? Well, to be honest, both are often required on larger schemes, but put simply, there's no cost to a guarantee, or at least a direct cost, as clearly the guarantor takes on a contingent liability. Also, in the current bond market, as Andrew has explained earlier, it's not easy to get a bond that makes financial sense. So with the correct guarantor, the employer can be protected from a failing contractor. Which brings us on to the next question. Who is the correct guarantor? Well, one of the fundamental issues we get with guarantees is the financial strength of the guarantor. So lots of companies will not give guarantees from the ultimate holding company. So if a contractor was to go insolvent, what are the chances of the parent remaining financially solvent? Also, there's a lot of construction companies and their subsidiaries and parent companies are so closely linked that if one goes into insolvency, it almost always means that so does the whole group. And you've got a list of group of construction companies there with ISG highlighted. I mean, it's a prime example there where 6 of their UK subsidiaries have already filed for administration, as well as their main ISG construction arm, which just further proves, it's not always guaranteed. So I highlighted earlier cross guarantees, but there's no fundamental reason why a guarantee needs to be provided from the same group if this is relevant. The key is to ensure that the guarantor has financial stability and credibility to back the guarantee. Also, something to consider is where the parent company is actually based. Trying to recover sums from a foreign-based company can be quite tricky, and the procedure is not always straightforward. So move on to the law of guarantee. So imagine now you've got your guarantor. The next step is to consider what actually needs to go within the guarantee itself. So I'll give you a chance to read the slide there. But essentially the two key points here are, firstly, there needs to be provisions in the guarantee that not only say that the guarantee will see to it, but also that the guarantor will indemnify the employer if any loss is suffered. And secondly is the issue secondary nature of the guarantee. So in its purest sense, a guarantee only guarantees that which was put in place when the guarantee was entered into. Did I say guarantee enough there? What do I mean by this? Well, absent to anything else, if a guarantee guarantees a scope of works under a contract, and then post the guarantee, the scope of works in the underlying contract actually changes or varies, then the guarantee falls away, as the underlying contract is now different. Now, construction contracts, this doesn't really work because there's always some form of variation, etc. So this needs to be dealt with within the terms of the guarantee itself. So there are a couple of key terms there on your slide, which you can see. So 2.1, the guarantor guarantees the due and punctual performance by the contractor of all the contractor's duties and obligations under the building contract. So that's typically an example you'll see of a see-to-it obligation, which we referred to earlier. And then 2.2 there on your slide, give you a chance to read that, is the indemnity to the employer if a loss is suffered. So people tend to get worried about indemnities, but the key point to remember is that there remains an obligation on the employer to mitigate its losses. Again, as highlighted earlier, so any changes to the underlying contract in theory nullifies the guarantee as the contract being guaranteed has changed. So this needs to be dealt with as well with wording such as what you can see there in front of you. This simply means that if the underlying contract is varied, the guarantee still subsists. So you can see the building contract may be modified, amended, or supplemented in any way without any of the guarantor's consent. Move on to the next slide. Again, similar to the previous slide, if for some reason the underlying contract was void or terminated, again, absent any further provision, the guarantee would fall away. So we would have to have a clause similar to what you can see on screen, which simply means that the guarantee is treated more as a primary document rather than a secondary contract. Right, we'll move on to the priority of claims now. So one other clause you should be looking for, especially if you're a beneficiary of the guarantee, is a priority of claims clause, sometimes referred to as a non-competition or deferral of rights clause. So the reason for this is a guarantor has certain rights against the principal obliger, so that being the guaranteed party, and a guarantor has the right to be indemnified by the principal debtor for sums paid under the guarantee. So the beneficiary will not want to compete with the guarantor for sums in an insolvency procedure involving the principal obliger. He doesn't want the guarantor effectively saying, well, I know I owe you money, but the contractor owed me money, so I'm going to set the two off. So if the guarantor successfully recovers money from the principal obliger before the beneficiary of the guarantee does, the beneficiary will want any money the guarantor has recovered to be used first to discharge the underlying obliger's debt. And this clause is designed to achieve that. So most guarantees therefore include an undertaking by the guarantor to refrain from enforcing its rights until the beneficiary has paid in full. The term of the guarantee, so guarantees as they guarantee under the underlying contract subsist until no claim under the underlying contract can be made. So typically that's 12 years. We mentioned earlier, a lot of companies will not give guarantees from their ultimate parent, but they are likely to if the period for which the guarantee exists is reduced. In practice, security is typically there for the period during the contract works. Whilst there is clearly the possibility of defect claims post-completion, the primary concern is getting the project completed. And we've seen a trend in the market now where guarantees are expiring at PC or shortly thereafter. So we've got a typical example of a payment guarantee there. So it will happen typically between an employer to contractor. Often the employer is an SPV in that situation, and similar principles, albeit payment only guarantee in this one. And it will expire at the end of the rectification period. Lastly, we move on to personal guarantees. Picture of Al Pacino there as Marco Corleone. I think famous for the quote, "It's nothing personal, strictly business." Well, sometimes it can get personal with guarantees. As discussed earlier, some of the smaller scale projects often involve personal guarantees. From the basis of a recipient, there is no point getting one if the person has no assets. So this needs to be checked first. And then secondly, due to the draconian nature of such documents, it can end up in someone's house being taken away. If the guarantor does not pay, then the court process could result in charging order or an order for sale of the guarantor's assets. So it's imperative that it is drafted correctly so it works, because the implications can be very serious. Also, whilst it's not essential for a director, it is highly preferable to insist that the person given the personal guarantee obtains separate legal advice, and that the solicitor confirms in writing to you that the guarantor has been warned of the consequences because of the reasons mentioned previously. Last point on the slide there is builders merchants. So we've actually had a number of cases where directors of quite large companies have signed builders merchants terms, and the wording of the signature often makes the director signing the terms personally liable, which again could have serious implications, as I mentioned before. So yeah, you have been warned. It's always best to obtain legal advice before signing anything. So yeah, I'll hand it over to Simon now.
Thank you, Baz. Thanks, Andrew. So we're now going to talk about other forms of security. Bonds and guarantees are the most common ones we come across, but there are other options if parties want to use them. So obviously other security, we've got two security guards, doormen standing there. I'm of the age where I remember it was Hale and Pace did the two doormen, but that's probably for a lot of your time. So what we're going to talk about here is we've got direct payments, escrow agreements, project bank accounts, and then also other different main options you can make maybe in conjunction with some of these other forms in order to change the cash flow model. So greater retention, longer payment terms, direct payment for materials. So as we come on to direct payment arrangements. So this is something we're seeing more and more of recently in developers and house builders in some instances, who have some standard amendments to their contracts to make the right to pay supply chains directly. And this is considered a payment under the main contract. We're also seeing direct payment to suppliers becoming more common, whereby employers pay for materials directly, effectively bypassing the subcontractor or the contractor. And this is vested. These goods are invested in the payer as part of the payment process. So we're just going to have a look about what they are, how they're used, key issues, effectively how they work. So the basics. So actually, the basic of a direct payment agreement is a right for payment to be paid direct, bypassing the middle party. So you skip one or possibly two change in the supply chain and make a permanent failure down. Essentially, it's making sure that the money gets to the person that it needs to get to. It can either be done as a right to make such a payment, but not an obligation, or a promise to make a payment. In our experience, the promise type of arrangement tend to be used with suppliers, and the right to make this type of payment is tend to used more in the subcontract supply chain. So the options above are typically where we see these kind of arrangements. where you've got a developer that's an SPV and a funder. So the funder may have concerns about the financial viability of the SPV. They make payments to the main contractor directly. It may occur where you've got a main contractor is teetering. Again, obviously we all know and have experience of main contractors having financial problems. So in that instance, the employer takes on the obligation to, has the right to pay the subcontractors directly. Or further down the next step down the supply chain, where you've got subcontractors who are poor credit rating, the main contractor may take the option to pay the suppliers direct. More often than not, quite often we see these things introduced post-contract. So during the course of the job, you'll have one of the parties struggling, and the employer and contractor is trying to find a way to circumnavigate that problem and get payment directly down to suppliers or the subcontractors to keep the project going. Move on. So one of the key issues to consider about direct payments is what we call pari passu rule. Now, pari passu does sound like an Italian footballer from the 70s, but it's actually the rule stated on the screen there. So it's a principle that all unsecured creditors in insolvency process, such as administration, liquidation, bankruptcy, must share equally any available assets of the company or individual and any proceeds from the sale of those assets in proportion to the debts due to each creditor. So it's effectively saying that all creditors of an insolvent company have to be treated fairly. Now, the situation we talked about before, making payments directly to subcontractors or suppliers. The issue we have is there's no actual common law right for that. So we can't say we've made a payment to a subcontractor. We can't turn around to the main contractor and say, well, I've paid your subcontractor directly, therefore that counts as what we should have paid you. That's a payment towards you. There's no actual common law right to do that. So obviously in the insolvency situation, the risk we have is any payment you make to your subcontractor or suppliers possibly offends this pari passu rule. That payment is to the subcontractor is deemed as a preferential payment to one of the creditors. So the risk you have is that you then may have to end up paying that again. So you have a insolvent main contractor. The liquidators for that main contractor come to you and say, well, look, that payment you made to the subcontractor, all well and good. We understand why you did it, but actually that was a payment that should have been made to us. Cough up. So in order to get around avoiding the pari passu rule, you need to make express agreement. You need to have some documentation and evidence of it. You can't just make the payment and hope for the best. So there's a couple of case laws that highlight the issues here, and apologies, I've got notes because some of these are quite detailed. So if I'm not looking at you, I'm just checking I've got the details of these right. So we said the problem is that you're in a situation where you could end up having to pay two lots of payments for the same work, one directly to the subcontractor and another to the main contractor, so you don't breach pari passu. So the first case we've mentioned here, Tate Building and McHugh. McHugh were the main contractor to Network Rail, and they were carrying out refurbishment to the toilets at Liverpool Street Station. I haven't been for a while, but I'm assuming they're probably better than they were before. And Tate were McHugh's subcontractors, and there's a company called Washroom Limited who were subcontractors who manufactured and installed bespoke cubicles on site. And these were regarded as crucial to the refurbishment. Tate got into financial difficulty. So the McHughs therefore removed the cubicles from Tate's scope of works under the subcontract and made a payment directly to Washroom of £145,000. McHugh maintained this occurred with Tate's agreement. Tate then went into a CVA, creditor's voluntary arrangement, and then made a referral to adjudication in respect to the full amount considered due, including the work done by Washroom and paid for directly by McHugh. So they claimed for sums of money, including the £145,000 that had gone directly to Washroom. In doing so, they'd contended they'd not agreed to the change of scope, and the adjudicator agreed and awarded Tate some sort. Obviously, McHugh's weren't happy with this, promptly issued proceedings to have the dispute dealt with in the court, as is their right. Take counterclaimed and sought summary judgment for the payment of the adjudicator's award. Those of you who are familiar with adjudication realise that you might not agree with the adjudicator's award, but it's very tough to actually get it overturned. McHugh's realised this, and so instead they asked the court to use its discretion to stay enforcement of that summary judgment application, because Tate's CVA, Tate's insolvency, meant they wouldn't be able to repay the adjudicator's award if they lost. So if Tate went, if there was a summary judgment on whether this sum was due, Tate lost, they weren't in a position to repay any money that McHugh's would have had to pay to them in accordance with the adjudicator's award. The court in this case decided that whilst they had agreed with the adjudicator and that the award was valid, it did use its discretion to say that the first £150,000 of the sum due should not be enforced. So obviously that covered the amount that McHugh's paid to Washroom. But in respect of that 150,000, they did have to make a payment into court, payment by insecurity into court of 75,000, pending the outcome of the substantive dispute, pending the outcome of the main argument. So it's clear from that sense you can see that the adjudicator had no compunction in ordering McHugh's to pay Tate the full amount, regardless of the fact that there was this payment to Washroom, and that the adjudicator's award was enforceable. While it did give McHugh's a little bit of a let off in terms of partially staying the enforcement, that was entirely at their discretion. So it wasn't a legal precedent. They just decided in this case that was the right thing to do. So whilst payment into court of 75,000 was more than Hughes bargained for when it paid Washroom with direct, it was a bit safe. It was a bit safer than being hit with the full amount, but obviously it still hits their bottom line. It's still an extra 75,000 they weren't bargaining on. So to come up to the second case, they have Action Strength and International Glass, which I refer to as Action Strength and England. The warning signs of contractor insolvency can also include withdrawal of credit facilities or unpaid subcontractors threatening to spend work. So, it's not necessarily quite obvious from the contractor itself it's having problems, but you may hear rumblings from further down the supply chain, and that may happen. As a result of that, you may decide actually you want to get ahead of it and make payments to those subcontractors to keep them on site before there's any formal insolvency proceedings for the contractor. Now, this is a bit of a risk, and that's highlighted by this case. So, in those circumstances, subcontractors may look and come to the employer as a guarantor of those contractors' payment obligations. The subcontractors may say, look, actually, the contractor's not performing, you're ultimately paying them, just pay us, come on, guarantee, we'll get the money from you. But without proper formalities, without the documentation and the recording all these agreements we mentioned earlier, there is actually no enforceable right by the subcontractor to those payments. And this case highlights this. The Action Strength case highlights this. So Gobain, I think that's how you pronounce it, contracted with England for the construction of a factory. England then subcontracted labour to Action Strength, but after a while stopped paying. Action Strength maintained that Sir Gobain had undertaken to deduct sums in respect of subcontract labour from payments to England and pay them directly to Action Strength, in the event of Action Strength keeping its labour force on site. Action Strength remained on site, but the money didn't come through. So Action Strength then sued both England and St Gobain, getting summary judgment against England, which then went into liquidation. Apologies, I'm just going to check my notes just to make sure I get all this correct. So England having gone into liquidation, St Gobain went, hang on a minute, okay, we're next in the firing line here for Action Strength, they're going to come after us. So to get ahead of it, Action Strength made an application for summary judgment. They denied Action Strength version, so they denied that they had agreed to assist them by paying direct for labour if they kept the labour on site. And then moreover, as a matter of principle, it said that an oral guarantee was unenforceable thanks to Section 4 of the Statute of Frauds Act 1677, which Shahbaz mentioned earlier. As we said, this requires guarantee by one party of another's obligations to be in writing as a guarantee, safeguard against false guarantee claims. This has gone all the way up to the House of Lords, and which has held that since then, since the 1677 Act, it's been reacted more recently in Parliament, as recently as 1989. And it made clear that Parliament had intention that oral guarantees were unenforceable. It made that quite clear. Action strength claim therefore failed because it didn't have any written proof to support its argument that Sir Gawain had agreed to pay them. So while it sounds like Sir Gawain won on a technicality, the requirement for written guarantees is understandable. It means that subcontractors have no recourse against employers who might make the right noises without backing up in writing. So the key here is really, if you're going to make any kind of direct payment agreements, or you're going to look for any direct payment agreements, make sure it's documented clearly in writing, because you're going to fall foul of these cases otherwise. We can have the next slide, please. So that takes us through direct payment agreements. Now come to escrow arrangements. In this instance, we're talking about typically they're used where the insolvent party or the party at risk of insolvency is the employer, rather than previously when we were talking about the contractor and possibly subcontractors. And it's commonly used where contractors won't carry out the works unless there's a secure pot of money on which they can call if in the event that the employer can't make the payments. So this is the definition from the City of London Law Society, which you read at your leisure. However, in simple terms, it's a pot of money sat somewhere that enables the employer to cover its losses, the contractor, to cover its losses if the employer doesn't pay them. So how does it work? So there'll be an escrow agreement drawn up between the contracting parties and an escrow agent. A sum of money is paid in interest-bearing account. As you said, it's typically used with employers' solvency is in question, but not always. But that's the normal time. So the employer pays in the escrow sum. The account is held by an escrow agent. Quite often solicitors get asked to do this, but there are a number of specialist escrow agent firms, holding companies that will provide these services. And then what happens is, if there's a trigger event, the escrow sum can be paid out, and then probably in more likelihood the escrow sum will then be topped up. So for an example, the client is that's a SPIV, but obviously we're SPV. No, they're not all SPIVs. So the contract sum of 5 million with a 10-month contract program. The contract requires some kind of security, and the client will agree to an escrow agreement. Now, there's a couple of versions which we'll come on to in a second. This will probably be a security pot version, and obviously they just need to have a conversation about how much money is paid in. The full 5 million. They may be happy to settle half of it. Obviously, depends on how the payment structure under the contract is arranged. So, as you said, we mentioned the security pot version there. So this is a one-off type of arrangement, and it's simply a lump sum of money paid into this escrow account, and that is repaid to the employer at the end, or more usually, it's used to pay the final payment under the building contract. It's a simple version. It's literally, we're investing this amount of money for the contract, and it sits there. If it's needed, it's needed. If not, it's used to pay the contractor at the end. The other end is the other version is the funding pot, and this is where the escrow sum is used to pay each monthly application and then topped up. So effectively, you're using it to fund the development. Obviously, for quite apparent reasons, this is a little bit more administratively heavy in terms of you having someone to have to certify payments, make arrangements for payments every month. But it does mean, from the employer's point of view, it does mean that they don't have an entire chunk of money sitting there that they can't access. They're not paying the full 5 million. In their example, they're not paying the full 5 million to a pot, which they then can't touch for 10 months. City of London Law Society has provided a very sensible form of agreement, which is the security pot version, which is the one-off payment version. But there are other types available. So, in order to obviously put an escrow agreement in place, you do need to understand what the contract works. So, obviously, the escrow payments, an escrow account is there to protect in the event that payments aren't made under the contract. So, you need to understand obviously what those contract terms say. So, which form of contract you're using. When does the right to claim under the escrow pot arise? The employer will have to have not met its payment obligations under the contract. So you need to think about how they're worded. How they're notified sum is calculated, what it is, any rights under the Construction Act, statutory rights under the Construction Act that apply in terms of payment terms, timings, notifications, etc. And then what will trigger the payment under the escrow? Is it the non-payment of a notified sum under the contract? Is it adjudication decisions, the court decisions? So you need to think about all these things about in what circumstances you want to be able to recover that money from the escrow pot, and how it works in conjunction with your underlying contract. This follows on from what we were saying in terms of things you need to think about. So you need to think about the underlying contract. You need to establish that there's a clear payment mechanism, so if it's not been complied with. You need to be aware that the escrow agent is independent and impartial. So even if you get your lovely friendly lawyers who've drafted you a really, really advantageous contract, if they're the escrow agent, that they still have to act impartial. So you can't have any sway over them. You think about long stop date. How long is the money going to be tied up? Is it in there to cover just the payments under the contract? Is it there during the rectification period? Things like that. You've got to be a time when that money is agreed to be released, any balance back to the employer. Size of the fund. As we touched on before, how much are you prepared to put in there? Is it the entire contract sum? Is it 10-20% of that? Is it topped up? How often is it topped up? And finally, you need to make sure that however you do it, it's done in a way that avoids creating a trust of that money. So you need to take separate advice and make sure that the agreement is set up in such a way to avoid that. And then moving on to another form of security which we're seeing quite a bit more of as well, a bit more use, project bank accounts. So these are used again typically when there's concerns over the contractor's solvency. They've been pushed by the government. As you're all aware, there's been a huge number of subcontractor insolvencies over the last few years, particularly at the bottom of the supply chain. So everyone's pushing hard to say that this is a way to try and negate some of that risk. It allows subcontractors to be paid directly. There are standard forms of project bank accounts, and there's several forms that can be used. So now it's going to have a quick look at how do they work and sort of the key issues that you need to think about if you're going to use them. So there'll be a project bank account agreement. The parties to that agreement will be the employer, the contractor, and all initial subcontractors. There is forms of additional party deed, which will allow any new subcontractors who might be signed up after the initial period or during the course of the works to join in and become party to the bank account as well. And certain contracts have enabling clauses to allow project bank accounts to be used. So the JCT has a standard form of documents that cover this off. There is the NEC, as mentioned there, the NEC UK1 option clause gives details of project bank account. argument, it is a little bit simplistic. It's not one I've used personally that often, but it is there and it's capable of implementation. But it might be one that we just need to need to tweak to put a bit more meat on the bones, as it were. So we said the works by all the parties join up to the project bank account, and then all sums due under the main contract are paid there. So the contractor doesn't pay his subcontractors directly. All of the sums get paid into this one big pot in the project bank account. Banks don't typically, as a rule, tend to like joint bank accounts. So we have to consider carefully about how you set it up and whether your existing banking will allow it. But it can be. There are people that provide it and understand it, but it might be one that you have to have conversations with your bankers about in order to get them to agree it. And then, as usual, under the contract, the employer's agent or the QS or the contract administrator certifies payments due to each of the main contractor and each joint subcontractor. So, as usual, they will work out who is due what, but they will, rather than certify one amount due to the contractor and then leave it to the contractor to decide, they will decide how that sum is due and allocated between the contractor and the subcontractors. And then payments are made directly from the project bank account to each of the parties, but obviously only the sums that have been duly certified. So it is administration heavy. It does place extra burdens on the employer's agent and the QS to pro rata payments and to check that all sums to all subcontractors are paid. But as I said, it's there to give some bit more of a peace of mind to subcontractors. The other final thing to mention on this is that there is a popular misconception. So it ensures payments to be made by the employer gets to the relevant subcontractor. However, it doesn't guarantee that those subcontractors will get whatever it's applied for, or even the sums have been certified. It's not a guarantee of payment, because there could be any number of reasons why an employer or a funder doesn't make those payments, as there would be under payments to the main contractor under a normal arrangement. For example, if there's a breach, if there's insolvency, clearly if a contractor has gone insolvent, then all payments under the building contract cease. So even if a subcontractor is sitting there waving a invoice saying I'm entitled to this money, it's not a guarantee of payment, because the payment won't have been made into the project bank account. And obviously any liquidated damages have to be taken into account as well. What it does is, as it says on the slide, it just stops all the money going to the main contractor in the first place. So it does stave off a bit of the risk to subcontractors that the main contractor is going to go bust and disappear. But it's by no means a guarantee that they will get everything they're due. And finally, just quickly, as we're pushing the time limit, there's some other options to consider about, to think about, and to give some consideration to. Maybe use these in conjunction with some of the others. So the first option is maybe don't use the cheapest contractor. It's tempting, but obviously the risk is that there's more likelihood that if they're operating for very tight margins, there's not a lot of wiggle room, and their risk of insolvency is increased. Best value is probably a way to look at it rather than cheaper. And then even assuming you have the best value contractor, you can look at possibly adjusting your contract terms to give you a bit more protection. Longer payment periods, therefore obviously you've got more time in between confirming and certifying payments and making them to take steps to avoid paying in the event of any insolvency, and to issue pay less notices, etc. You can consider a higher retention. The only note of caution in terms of higher retention is that they have been identified as one of the main drivers of subcontractor insolvency. So you have to consider whether holding back more money in the event they do go insolvent is actually just fast-tracking their subcontractor's insolvency in the first place. And then finally, obviously, stage payments. You know, rather than paying monthly, have stage payments 3 months, 4 months, 6 months in the PC. Obviously, you're risking less money earlier, and then gives you, you're in a slightly better position in the event that there is an insolvency, because you haven't necessarily paid out huge chunks of money under the contract, and you've saved some back. So whatever other options of security you use, these things are worth considering as well. But as I said, you know, the thing to remember is, you know, you're protecting yourself, maybe imposing some higher risk on the subcontractors and risking their insolvency as well. Bit of a canter through. Hope that was useful, and we are now available for any questions.
We are, but as we've literally got the hour.
Yes.
If you've got any questions, guys, then just send them through and we'll answer them post the call, because I'm sure Heather will tell us that we've used our hour anyway. So thanks very much for that. The vast bulk of you have stayed with us all the way through, so that's really good. Hopefully you've got something from that, and we'll see you again soon.
Thank you all.
Cheers.